the transverse tunnel that goes through under the coolhouse. How many different ag users would be affected, approximately?
Well, withdrawals now vary. I don't have the numbers, but there are clearly, if you imagine, if you imagine in your mind's eye coming through Wyaba, going through Middle and then coming down through Cornelia Road to the endpoint of Market Field, clearly all the former Campbell Estate lands are in some state of agricultural use. Castle and Cook has some uses. The lands that are west of Wheeler and along the east side of Cornelia Road are beginning to go into agriculture. So I don't have a number for you, but you could look at the water use permit list on Wyoming. There's currently on the order of, I'm guessing, 10 to 12 million gallons a day used, maybe slightly less, depending on what crops are up now.
So it's very many, in other words.
Yes, and there's increasing ag being put in production. The Robinson lands are very just. They depend on that water.
So if one user has the unique ability to back that up with water from an adjoining aquifer, a separate aquifer, wouldn't that give everyone else the a precedent to use to be able to do the same? And at that point, would that not likely exceed the sustainable yield of the available?
I don't know, because that contingency depends on understanding where the break would occur, what the current needs are. It would lead to a whole series of problems to solve the loss of water. The solution, if the siphon were to go down on the eastern side, the solution may be to have a well that is closer to the break, for example, assuming there was one in the distance, and just putting water into the ditch so everybody supplied the same way. So the number of contingencies you sorted out are multiple, and I don't now have an answer for how all those would be met. I mean, one possibility, frankly, would be figuring out some way to divert Lake Wilson water into the ditch as an immediate remedy. I don't know what the physical requirements of that would be, but that may be a solution faster than it could go well. But it may also, if done in the right location, just drop water in the ditch, and therefore everybody can continue to be supplied. I don't know how fast you can lay PVC pipe. I mean, that's the kind of thing you might have to consider.
Lake Wilson is over the mountain.
True, but you pump it up a little bit and have it go down, as opposed to pumping up a lot.
A lot of work, a lot of time.
One more question, Mr. Chair. In previous rulings that the Supreme Court, the state of Hawaii made, I believe with the remand on Waiahole for one, was the issue of whether backup for irrigation a reasonable and beneficial use, was that ever brought up?
A backup in the sense of a duplicate allocation?
Yeah.
It's never been granted. It would be inconsistent with the notion of an actual reasonable beneficial use. So the concept is a contradiction in terms. There are cases where people in the past have had multiple sources, and that's fine. Newman Schools, for example, has historically had uses, and they have unused wells. But that's not granting a legal right for a dual purpose. I mean, the goal of having backup sources, it makes sense in terms of practical purposes. That's fine. But the notion of granting two different rights when others are in competition for that is a different proposition.
Yeah. In the Monsanto's reply, under special condition 8, that certainly takes care of the perpetuity that you spoke of in the first time. I mean, they say you get to a certain level, 95%, we're out of here, and we've got no quarrel. So I think that pretty well eliminates the first argument.
As a matter of law, it's not.
Well, I'm just saying from a practical standpoint, I'm not a lawyer.
From a legal standpoint, it does not.
Well, I obviously the law firm thinks otherwise.
Law firms already argue that case, I'm advising
Okay,
you
all right,
can't do it.
I'm talking from a practical standpoint,
Okay,
sir.
that's kind of practical.
And, it's impractical?
No, I understand your point. from a
Okay,
practical
all right, so hear me out. That's, the other thing, the other part that I have approved that the following terms and conditions are met, item B. I mean, that's not very, practical. I mean, that's for the state to determine.
I'm sorry, item B where?
To be.
On page 17.
Okay, top 17.
2B.
Right.
That's for the state to determine, not for the user, I would think. I just, again, as a practical point of view.
The obligation would be on the applicant to find out, and provide that information. It may be good, it may not be good, but they've got to go and ask ADC, for example.
The water's not coming, I mean, it's not theirs to determine, it's the state's to
It's not a
determine.
matter of determining, it's a matter of going and getting the information provided to the commission. They'll go to ADC and say, tell us how much time it takes. They'll convey that information to the commission. They're not making a decision about how much time, but
I would be, if I were a user, I would be very reluctant to be, to be Paul parroting what the state said. I think the state needs to talk to us and tell us, not the user. I mean, come on, you're going to a third party and
there is a predicate by which an application be processed. Whether that's accurate information or not, and whether we rely upon it, that's a different question. But in order to have a claim to do something, you have to make an estimate. And with a footnote saying, this is ADC's estimate, we don't agree with it. That's fine. But it's like a logical proof issue. You've got to have that information in order to make an argument that we need the water for 3 years or 5 years or 2 years. It's got to be some factual basis for that statement.
Yes, and again, I think that's the state's position to tell us, not the user, because again, it's the state that's gonna make the decision. They know what the break is, they know how long it's gonna take, and for somebody standing on the sideline saying, well, that's what they said, well, I mean, that's not worth the powder to blow to kingdom come.
But they've got to make the argument that because the ADC tells us it won't be available for 10 years,
All right,
they won't
okay,
do it.
fine.
We'll still check it.
That's, I think it's a ridiculous requirement that holds no water, but that's a personal opinion, so you hear me.
Okay. Thank you, Ben. Any questions from you?
Bill, by definition, back in this context of double counting, doesn't it mean that waters will not be used simultaneously? So how do you get double counting?
Well, it's not that. Well, there are 2 rights. Those rights stand alone. They're not conditional. When you issue a water use permit, it's an indefinite grant of a right. Okay? It's not contingent on something else. So you can't do that. That's the problem. It's not like, and the other issue is, we get into the logic of granting that same permit to all other people in similar situations. That's what you've got to stand back and say. This particular applicant aside, if this is now the law, then everyone else in a similar situation has a similar right. Okay? If you do that, you've basically allocated out the water for contingent uses, which would prohibit somebody else. Let's say that's all done. It's 100% out. That would in effect prohibit us, the Water Commission, from granting a permit to the next person in line who wants an actual use, because you will have in effect used up your allocation. You can't have a double counting. It doesn't work. It would lead to a situation where, let's say Dole comes in and says, we need 10 million gallons for some use, but all the water has been contingently allocated out. You can't have both. Water use permits are an indefinite grant of a right, and you can't just pull it back willy-nilly because that's not convenient now. Unless there's a non-use, or you change location, amount, or the purpose for which it's used, you can't just withdraw a water use permit. This is not like a lease. As part of the arrangements when the code was created, that in order to protect agriculture from this kind of activity, they were indefinite leases, indefinite periods. That's not done in other states necessarily. There's a long debate about that. But because of that indefinite right, you can't just pull it back. They're not short-term permits.
Well, again, go back to the word backup. So it means you have a backup source to utilize on an interim basis until the primary source gets restored. So that allocation you're talking about is going to be disappearing maybe for a short-term period until the primary source gets restored again.
But you don't, when that occurs, you could grant the water use permit at that time, but not contingently for some event we don't even know when it may happen. Because it forces us to create a reserve within that allocation against that contingency. And what happens if, let's say there's 20 million gallons left in to be allocated, and new users come in and you grant permits for all those 20 million gallons. What value then is that conditioned permit in the future? You can't pump it, or somebody else has to give it up. Now, you get into those situations if you face a reduction in sustainable yields, then we're going to have to review all the permits. But in terms of new grants, it's an unsustainable proposition in terms of going forward. That's the problem. I mean, the real solution is to get their well in, to get the pump installation permit in, they do the pump tests. A crisis occurs. That may be the solution. Maybe something else is the solution. Depends on the crisis. And so to presumptively say that's the solution to a problem we don't know yet puts the commission in legally an untenable position. I mean, this will provide the solution they need. They will be able to come back to the commission and say, we had a failure in the Waialae ditch, we need to pump this right now. Chair calls the commission and says, this is what's happened. We proceed under the code or under other authority to deal with that problem. So the problem's going to get solved. It's just not going to get solved the way it's been proposed in their application. We had to modify their approach to conform with what the legal needs are of the commission. I mean, they're going to have it available to them, a mechanism to solve that problem. We're not leaving people off the fly, but we can't do it the way they're proposing. That's what we're suggesting here.
What other authorities are available?
Well, without getting into the details of how the shortage plan, the emergency powers work, and it's unnecessary at this point. Methods to solve these problems are not limited to the statute. Clearly, the Hawaii Supreme Court has said, and it's true as a matter of law, that the sovereign has police power authority to deal with emergencies. Let's say it was a health problem. Let's say it turns out there's an application of a pesticide in some portion where the Waialae ditch is served, and that water then became contaminated. It wouldn't be a matter of a siphon. It may be a matter of taking a month to clear it out or whatever you've got to do. That situation has facts that are unique to that situation. We don't know what those are yet. The well here may not be a solution to anything. It may be contaminated. We may have to do something else. So we want to think about the possibilities, but we don't want to have one fixed answer now that may not even address the problems that arise. And frankly, it is inherent in the obligation of the Commission on the Public Trust Doctrine and as the state to protect the public health, safety, and welfare of the people. And that authority supersedes any statutory provision. It cannot be the law that the Commission sits here and says, we're going to take a month to decide how to deal with this. It is like a fiduciary. If you are a guardian for someone, you do not have to sit there with your eyes closed and your hands tied, go through a process when somebody's very well-being depends on it. It is the nature of being a public trustee that that's what you do. When there is a tsunami, you try to follow all the rules, but if you have to go out to save somebody's life, you're going to go do that. It's just the nature of what your obligations are. That's what a guardian does. And those are public trust responsibilities that supersede particular statutory arrangements.
Any further questions?
Yeah. Bill, is the staff's major concern that if we do approve the applicant's application, that it would set a precedence and that you think we would get a rash of
Yes.
people?
Anybody in their right mind would come in very quickly.
But then again, wouldn't it be approved on a case-by-case basis?
Not if you had the same situation. There was no legal principle basis. You could then say, we reject this one. Because you'd be getting into an endless series of differentiations that assume somebody comes in with the same claim. And many people who depend on surface water systems are in the same situation in the water management area. I want to drill a well now because, gee, I might lose my surface system. Yeah, everybody's. I mean, they're not alone. And from a business point of view, it certainly makes sense you want to have backup. That's not in dispute. The question is whether the commission should use the water use permitting process as the mechanism to do that when the implications for the whole code, it unravels the code. There are other ways to handle it that don't implicate that problem.
On the time side, any question? Okay, thank you.
Thank you. Good morning, Commissioners. Yvonne is on behalf of Monsanto. With me today are several members from Monsanto, backed by the Land and Water Resources Manager for Hawaii, Tony Herman, who manages the Kunia Farm, and Yarrow Flowers, who keeps Dan in mind. This is the third time I'm appearing before you today on this matter. And I think, from the staff's presentation, both in August and today, the staff basically concurs with us that, except where we may disagree on the public interest item, that the water use permit that Monsanto applied for, we have met all of the criteria in HRS 174C-49A for new water use permits. The staff in their submittal listed 6 reasons why they didn't think that Monsanto met the criterion for public interest, and we've addressed that in the submittal that dated November 16th. Listening to the staff's presentation today and the questions that have come out from the commissioners, I want to address what I think are two basic issues that the commission needs to deal with. First of all, Mr. Tam said that when asked about the special condition that Monsanto had proposed, that when the allocations for the Waipahu-Waialba aquifer reach 95%, that the commission has the authority to either reduce the allocation or revoke it, and Monsanto has agreed that we won't ask for a contested case on it. Mr. Tam indicated that you just can't do that because rights are not conditional. All water use permits are conditional. I mean, you have standard conditions, and you have to abide by those conditions. If you don't abide by those conditions, then your permit can be revoked. What Monsanto is proposing is, in addition to the standard conditions, that there be a number of special conditions. And special conditions operate just as standard conditions. If you don't abide by those conditions, your permit can be revoked. So one of the special conditions we propose is that when allocations from the aquifer reaches 95% of the sustainable yield, that the commission can come back, reduce our allocation, revoke our allocation. You folks can decide at that point what you want to do, and Monsanto has agreed that it will not ask for a contested case. All it's going to take is one meeting in that case, and it's not going to be dragged out through years of contested case. So that somebody else who's waiting in line with a permit application, especially, and this is something that Monsanto met with the Honolulu Board of Water Supply before we even filed the application. In our discussions with them, they don't have any immediate plans to ask for additional allocations. If they did, and we felt that the BWS was going to be eating up the rest of the sustainable yield, believe me, Monsanto is not going to invest this kind of money for that. So I'm not. I don't understand what Mr. Tam's point is about how these rights are not conditional based on the conditions that Monsanto is proposing. We definitely conditional. As we pointed out in our submittal, you know, I think the conditions that we propose, which are 10 in number, they address every single issue that the staff had raised with respect to the public interest. When it talks about double allocations, there's a number of conditions which state that, one, you can never exceed, you know, both the Waiholi ditch permit and this backup well permit, you can never exceed the total Waiholi ditch allocation, which is 2.636. So you can't use double the amount. So when he talks about it's not economic or efficient use because you have double the amount, well, that's not true. Under the special conditions, that's not going to happen. It says that you can only use it where on the locations for the purposes and in the amounts and the water duties that's allowed under the Waiholi ditch permit. Again, we're not talking about double allocation here. You know, the total amount of water that can be used from Waiholi and this backup well will be 2.636. If Waiholi never goes down, then we won't be using this well. If Waiholi goes down for, you know, a period of 6 months, you can only use the well for the 6-month period that the Waiholi ditch is down. So we don't see this as a double allocation. The other one of the special conditions, which is actually a standard condition, it says should an alternate source of water become available, this allocation may be revoked or reduced or revoked. And the thing that's special about this, as opposed to the standard condition, is that Monsanto agrees that it won't ask for contested case when that happens. So I think we've addressed all of the concerns that were raised by the staff in the public interest section. Again, I don't agree with Mr. Tam that rights are not conditional. I think they definitely are conditional, and I invite you to talk to your AG about that. And it's not a duplicate allocation based on the conditions that Monsanto proposed. The other item that I wanted to talk about, and Mr. Tam had said that, you know, we don't have to go into the interpretation of the emergency provision of the water code today. I think it's absolutely necessary to go into that, because that is the basis for Monsanto objecting to the staff recommendation. If we did believe that, you know, the commission had the power under the emergency statute, if we were convinced that we could turn on the pumps when the ditch went down, we don't want to fight the staff, okay? And it's just that having read the emergency statute and the water code provision, section 48, which requires that any withdrawal of water from a water management area requires a water use permit. I just don't know how you get around that. Staff hasn't addressed how they get around that. The emergency provision, section 62, doesn't say that, you know, all other provisions of the water code notwithstanding. It doesn't say that. When he talked about, I think it was the chair that asked what other authorities there are, and Mr. Tam talked about the duty to protect the public health and safety. So if you look at the entire HRS, the way to deal with those emergency situations is for the governor to declare an emergency and issue proclamation. Boards and commissions, unless the statute provides for their authority to suspend laws, the boards and commissions don't have that authority. Only the governor does. Take an example for conservation district use permits. When there's an emergency that happens, the Board of Land and Natural Resources, there's provisions in the board rules and regs about filing for emergency permits, which call for an expedited process. There's also a process in which you can apply for after the fact permits, because the emergency happened and you just had to go in there and act, but you have to apply for after the fact permits. But to suspend the conservation district laws, it's the governor that has to do that. The governor has to declare the emergency and suspend the laws. There's nothing in the water code that says that when some kind of emergency happens, that the commission can suspend the laws. You have to go through the governor. The other thing is, the staff is suggesting that go ahead, issue us a pump installation permit, and when the emergency happens, that the commission can immediately meet by phone or whatever, and then grant the water use permit. I suggest that it can't, because if you look at the water code, issuance of a water use permit includes requirements about public notice and those sorts of things. And you just can't call an emergency meeting and issue the water use permit that way. So as much as we would like to find a way that staff can be happy, we just don't see, under the parameters of the water code as it exists today, we just don't see any way for the commission to allow for backup sources of water in water management areas except through issuance of a permit. And for that reason, Monsanto is requesting that the commission grant a water use permit for backup from the Waikapa-Waiawa aquifer for 2.636 million gallons per day, subject to the 10 special conditions that Monsanto is proposing. It's on page 7 through 10 of our November 16th submittal. And also subject to the standard conditions to the extent that they don't conflict with the special conditions. Thank you.
Any questions for you, Lon?
Sure.
Why 95%? Why not 75%? Why not 65%?
Well, the Waikapa-Waiawa aquifer today is, the sustainable yield is over 104 MGD, 104 MGD. So 95% leaves, more than 10 MGD available. 10 MGD, when you're talking about domestic uses, is a lot of water. I mean, basically, you're talking a huge development project. Those are the kinds of things that, you don't have an application, and you don't hear about it, and 6 months later, they need the water. I mean, those are the kinds of things that are going to be long-term. So, we thought that 95% was, with the 10 cushion, was an adequate amount of water to use.
The conditions of no contested case, Monsanto is willing to do that. So does that predicate that Monsanto can take some any legal action if we decide later on to eliminate or reduce?
Monsanto clarified that we won't ask for a contested case. We would definitely, and we think that, from the commission's point of view, you should review it rather than it just be an automatic revocation or an automatic reduction. That the commission should be the ones to make that decision. And definitely, Monsanto would like to come before you and state its case, whatever the case may be at the time. But if you're asking whether we file a lawsuit against you, no, we're not looking at those sorts of solutions. We just want an audience before you, like today.
But if you disagree with the commission's decision, you would have that opportunity, right? Monsanto would have that opportunity.
The opportunity to
Question the decision of the commission by going to a judiciary process.
I believe not, because I believe that under the Administrative Procedures Act, we would have to exhaust our administrative remedies, which means that we would have to ask for a contested case, and since we gave it up.
You might not be able to answer this question, but perhaps they would. There's a potable water line on Kootenai Road.
Correct.
Has any thought been given in this entire process to simply asking the Board of Water Supply for access to that water line in the event that there's a catastrophic failure of water leakage?
Yeah, I believe, we met with Board of Water, like I said, before we even filed the application, and, yes, he's very serious. My recollection was that because you don't know the extent of the emergency, that Board of Water Supply wasn't willing to commit that we could use that as a source.
In my mind, you can look at, let's say there's a construction project nearby, and they all seem to hook up to the fire hydrants for water for a period of time. So, would you make coming up, right? I hate to put you on the spot. And you may not know the answer why.
Yeah, I don't know the answer.
I'm just curious why, you would, in the event of an emergency, try to work it out with Water Supply, hook up to the nearest fire hydrant during the time of the emergency.
There is a question of service line. Our reservoir is at 645 feet elevation. I'm not sure where Monsanto is, but I think it's about the equal elevation. So I don't know if there will be sufficient pressures to fill the ditch, because I think it's right next to the ditch. Maybe the Monsanto has confirmed. Yeah, our reservoir is right next to just below the ditch. Right. So hydraulically, it's difficult to pump it up there. Of course, we have temporary pumps. So depending on the emergency, I think we may have some flexibility some capability to do that. But normally, the emergency or temporary water meters are off the hydrants. They're 100 feet below elevation, 100 feet below the spillway elevation. So it would be in the vicinity of the Roconia subdivision, and a temporary meter would be hooked up to the fire hydrant, and they could utilize that. But it's a 4-inch connection or 2.5-inch connection, typically, and that doesn't flow to 6 million. That's too small. So there's a capacity and there's a pressure issue.
From a practical standpoint, you couldn't stand the jerk for 2 million gallons a day. Probably.
Yeah,
all probability.
And still serve, it's not designed for that amount. But, we do have 3-inch booster pumps that could pump directly, could pump from the reservoir line into a ditch. But I don't know if we have enough to meet the pool.
Okay, explore all options. So, board members, any other questions or commission questions? Any questions?
Just a comment, Chairman. I think we're so close and yet so far away, but can Mr. Tam address some of the issues that Yvonne had?
Sure.
Thank you.
I'll try to do them in order in which you raised them. The question is whether the public information or points were addressed. They were addressed in the sense you talked about them, but they're not answers. Okay. It is not a reasonable beneficial use or grant a permit for zero or for a non-use. That's just not hard. With regard to the 95% rule, the problem is the Monsanto is now making public policy for the state with regard to when a sustainable yield number can be used. The problem with the contingent notion of this is there are going to be more applicants coming in as more ag land goes on into production, as lands north of Waiava go into production. There will be more water use applications that come in. Let's assume 5 years from now nothing's happened. Water use applications pick up as all of central Oahu lands get used. Let's say we're at 100 out of 104 million gallons. Let's say we're at 104. Let's say we're maxed out. Then you have a contingent use here, and there's a failure. Who is it that changes in order to accommodate now water use permit allocation that is beyond the sustainable yield? Let's say it goes on for 5 years. It takes 5 years to fix the cycle. You've now got a situation which you've legally granted out more water than there is. And you've granted out water to somebody that already has an existing source. So the logic problem is not solved by conditions. It is not up to, Yvonne's characterization of my statement, unfortunately, is, maybe I need to be more clear about what conditions, clearly there are conditions and permits. The problem of granting out a legal right to take water, which is what it is, otherwise it doesn't mean anything. I mean, Monsanto is in no different situation than everybody else relying on surface water. So everybody else has got the same claim. So you could very quickly double the amount of allocations right now. You also have all the lands that have not been in production. They're going to come back and request. The reason we're not pumping that much now is after a while sugar went down. The Waihoe water is not in production there. It's actually been fairly small relative to what they thought. But as those lands go into production, there's a reason it's low now, because that's the water that will be used to a large extent to bring back all that agriculture or urban growth. The Board of Water Supply counts on that for sources for EVA, for example. EVA does not have potable groundwater, and yet all the growth out there is contingent upon the water from Central Oahu. So the notion that that somehow is going to be enough gives us no planning in the future. So the special conditions, obviously the conditions in every permit, but that leaves the Water Commission now at the mercy of Monsanto coming back and saying, okay, we'll consider something. That's not the way the law works. They're a permittee. They aren't driving the public policy decision. With regard to how we deal with a withdrawal of water, clearly we could, if it's required, and I'm not prejudging the issue at this point, say the water use permit application should be filed as soon as there is an emergency. We'll consider it on an expedited basis. That may be the way we have to handle it. What if the entire universe of Waihoe dishwater users all come in at the same time? They all face the same problem. There's nothing special about Monsanto in that case. They want to come in. With regard to the Board of Water Supply's description of what their water supply capacity is in Canea Road, that's not the only source of water. You can drop water into the Waihoe Ditch in various places. It may be more useful to drop it in closer to Wheeler rather than down the road, so you serve all those needs. There is currently, and again, this is not something that's presently available, but is in the works. Schofield Barracks is treating water R1 for irrigation purposes, and they have the capacity to drop some of that water, or Lake Wilson water, or Waiawa wastewater treatment facility, Lake Wilson. Some of that water could be dropped in the Waihoe Ditch very simply. There's already a physical infrastructure to do that. So that's a contingency that can be handled. Those haven't been explored. So I don't know if I've addressed all those issues. Is there something in particular you want me to touch on, the ones you want answered?
Well, my main, at this point, because I say we're so close and yet so far away, is that 95% thing. You mentioned that, in essence, Monsanto is driving policy, or whatever, when to stop.
It's very convenient for them. I understand why they're doing it. That doesn't mean they get it right above everybody else and preempt everybody else to stand in position and direct how it's going to be handled. They're going to be, along with many other people, facing the problem with why the ditch goes down. The commission is going to face not just Monsanto, but everybody. And so to have them be first in line compared to everyone else with a water use permit goes beyond the realm of what's reasonable and just isn't allowed under the law. It's not that we're trying to figure out a way to help them, but this is not the mechanism. It creates legal issues that are untenable. It creates basically a water rush for permits because they don't have to have a permit. They can come in when they need it. The permit is a way to come back to the commission and say, I have a right, you can't take it away. Sure, maybe they won't go to contest the case, or maybe they'll file a federal lawsuit. They'll claim you've taken my water right away from me. You granted a right, now we're going to take it away from you. The hell with the state courts, we're going to go to federal court. I spent 15 years of my life dealing with that argument. I'm not interested in hearing it again. Okay? Disingenuous.
Thank you for helping us understand.
I've got a question. Assuming that we go your route where they're allowed to do a well, but not a permit, how long, in your opinion, would it take from the time of a failure to the time you can actually pump?
Assuming the situation is decide to fail that particular issue.
Okay.
And there will be other applicants that come in at the same time. The commission will first have to say, if we have a system failure, then we're going to have to look at not just Monsanto, but everybody. Okay. And the solution may be to satisfy all the needs. We may want to use water resources that are available up by Lake Wilson, up by the Schofield plant, and see if those can provide some of the needs. Assuming not, assuming that the first thing you need to do is pump the well you got, then on an expedited basis, the commission could meet. We use the processes that are in the code as well as other authority and say, we're going to grant water use permits, and with the condition then, for all the water use, because everybody else will be in the same situation, that will be withdrawn for the whole group when the Waihoa ditch is fixed. That'll be the problem that will be faced then. But then you'll know what the problem is, and you will grant those on the notion that water is no longer available. You will genuinely have a shortage at that point. And so, under the code, you can use the shortage university powers. Those can be done as quickly as the commission can meet, and we can get through a process. My guess would be within a week to 2 weeks, if that were the case, if all that agriculture was threatened, we could meet around the clock until we had the things done. I've done that.
Just for the record, 2 weeks would be way too late for, if you're growing a crop, in most cases, 2 weeks would be too long.
I'm not prejudging what
Okay,
the number will be. We can meet around the clock to solve it.
There's gotta be a practical time frame to be able to do it, to be able to save whatever you're trying to save.
I think under the current emergency powers, and maybe some disagree with this, but my view is under the current emergency powers, the commission could authorize on an emergency basis pumping almost immediately subject to a 10-day review. And notice the outline that we had in the conditions, I think the commission can do.
Is that absolute or is that just an opinion?
Absolute? I don't know what it means, absolute. My view of the law is it allows it.
You say the law is absolute, so.
No, I didn't say that.
Well, you.
The law, I think the law allows
provide
that. My view of the law is it does allow it.
It does allow it.
Yes.
Well, that gives the user very little comfort. We think we're talking, I don't know. One other comment. I mean, you made a statement to the effect that Monsanto was dictating to us. Well, I don't know. I look at it a little bit differently. You had a bunch, or not you, we had a bunch of conditions or situations where we said it won't work, and so they were kind of trying to come up with a solution so that I mean, the 95 days or 95% was a suggestion to solve the problem. I don't think it was dictating. I'm defending them right now because I think they've been put upon a little bit here, but that's again a personal opinion.
They're asking for a right. It's not their decision. It's not their call to say what that right is by the commission. They're asking for it. They're applying for it.
They're making a suggestion to
Right.
solve. You have an objection, and they're coming up with a suggestion as how to solve it.
They would solve it for them. They would not solve it for the commission.
Okay, all right, fine.
Well, I'd like to suggest that we move on to public testimony, and then after that, I'd like to ask for an executive session to talk to the AG's office to answer some of the, we have two lawyers who are very understand this law, and we have a conflict between what's been said, and I'd like a little bit more legal discussion between myself.
I would agree with that. We probably have the two smartest lawyers in the world who would disagree.
I
It makes it very difficult for us to.
Yeah.
Let's hear from the public.
Okay, so, any members of the public who wish to testify on agenda item B2? Lots of people in the audience.
Monsanto. I'm here on behalf of the Office of Hawaiian Affairs. We just had a few comments to offer on agenda item B2. The Office of Hawaiian Affairs shares concerns with the staff recommendation regarding the applicant's request for a reservation of water for a hypothetical future need for a private purpose, which we feel may be inconsistent with the state water code, which requires a consideration of actual needs and to the extent to which they serve reasonable beneficial public purposes. If the applicant is looking for, I guess, a more reliable or resilient water supply than the current situation with the current allocation from the Waiho Ridge system, we believe there may be an acceptable alternative that would be worth exploring, and that would be basically granting a water allocation from the Waiava aquifer and replacing the current allocation, which is from the Waiho ditch. And the reason we say that is basically we'll be granting them the allocation to tap into what is currently unused water source. Whereas the Waiho ditch system, there are already recognized existing competing issues with regards to the environmental, cultural, and domestic public purposes. You know, what is that? Yeah, that's what it is.
Any questions?
The sheer practicality of it again is that there are a number of siphons between the Waiava and the Waipahu aquifer, and if you're talking about siphons, and it is a siphon, that's not a solution. I mean, just again, from a practical standpoint, you go up there and you walk the system, you will understand that. So that's not to say there's not other sources, but as far as your solution, it could still be a problem.
My understanding of part of what you said is that if they want the assurance that of a groundwater system, that they should apply for the groundwater system but terminate their use of the ditch system, thus freeing it up for other agricultural and also cultural as well as environmental uses. Am I correct in that?
When did you find out about this application?
We saw the initial application from August, I think, maybe a month ago, and then we've just kind of been, watching the agendas to see when they'll be up for consideration, and so it just got posted last Friday.
What prevented you from testifying back in August?
I actually just started in September, so I'm not sure what office back then.
Regarding the second paragraph in your document, you say that it's an indefinite allocation for hypothetical uncertain use.
Okay.
The submittal seems to be very clear that it's for a backup source for 2.636 million gallons. What do you base these comments on?
Well, I think within the submittal itself, the contingency that considers isn't clearly defined, and that's what we mean by hypothetical. There's no, we don't know for sure what's going to happen with the ditch. You might, be applying for, some years, you might never get up there. That's what we mean by uncertain.
But wouldn't the word backup, give you an idea as to what's being requested here?
It's a backup it's a backup for a contingency that's uncertain.
Okay, any other questions for Will? Thank you. Another hand for Lee?
Hello.
daughter, Kula Ilari. I want to share with you guys the catastrophic problem with our water is that it's going to people like Monsanto instead of to the Opelu. You smell that? It's the last of the Opelu on the Waianae coast. There is not a single river that runs 12 months of the year to the ocean. For 7 years, I've been trying to get land to farm cotton. These are the foods that sustain our family. Yet somehow someone can claim to get millions of gallons of water for non-human consumption food. It infuriates me that you would even consider it for a second. Monsanto never asked the people if we wanted them here at all. Let it be clear that the fish and the taro of Hawaii tell Monsanto to go home. There's not enough water here, move. Because the water is for the fish and for the kalo and for the people. We talk about sustainability. We produce 4 million pounds of kalo a year. It is our staple, it is our starch. We need at least 365 million pounds to feed each and every one of us 1 pound a day. My family of 5 consumes 300 pounds of poi a month. If each family in Hawaii were to consume the same amount, there would be no water from Monsanto, and we would be sustainable. I'm here to convey to you that the real voices that you're not hearing are the ones who can't afford the $2 an hour parking and the gas to drive here. Because right at this moment, they're at work, struggling to buy what? Rice and high fructose corn syrup. We demand that you do the right thing and set the precedent and let these folks know that our water is for food and for people. Thank you.
Any questions for
In the event that the request is aborted, then if there is a problem with the irrigation system, then the priority for that emergency would be that Monsanto would get water to be able to continue, but everyone else farming food would not. Do you feel that that is an equitable vision?
I can't even see how that would be a part of the vision. You know, if 85% of what we currently consume equates to $3.1 billion, farming and feeding ourselves is the single largest growth of industry that we have in front of us, which needs massive amounts of labor. For farming and producing our own food, we will in turn manage our resources much better. They are using this simply as an export, which does not apply to a single one of us. In fact, Hawaii is contributing the single largest contributor to chemical farming in the world through our means of exporting corn seed. Now we need to stand up for this. Our water is not meant for other countries to grow GMO corn. This is serious. Your decision today, in part, will send a clear message that they're not welcome here and that our water is for food.
One more question. Are you farming kalolohi?
We currently have, we don't have a lease. We have a small plot in Kahaluu to restoring some ancient patches. We are in discussion with many entities, but the reality is to farm taro, you have to live on the aina. And they refuse to let you live and farm.
Live your dream.
Anyone else wishing to testify on this matter, going from left to right?
Morning, ladies and gentlemen. Morning, cousin William. I am Kumaoli, Councillor Paili Lincoln. come there May 8th. Dirt descending off from there, there one. You have the documents right here to prove it. You wanna see it? Monsanto has been poisoning our land with poison. You see this? That's what I want you to think of before you make a bad decision to allow these people to dig a well on our land for water. Go green, think green. When those other 48 states decide they ain't got enough food to give to us and send here to us in massive container, we're gonna need every inch of land to farm food to sustain our children and our grandchildren, including ourselves. Now what are we gonna do if we keep allowing these big corporations to come in here and just take control of our INA? What are we gonna do for our children and our grandchildren? That is my question to you, all of you. Because I know you have children and grandchildren like I do. I'm very worried about these people coming here to just take full control of our INA. This INA belongs to all of us. Every single one of you, me, and those behind me. We're not gonna sit around and just let these people come here and take control of our land. We cannot do this. Together we have to fight them and we have to stand up to them and let them know these things that they are doing are really wrong, very bad for us, for our keiki. This is not allowed and we must let them know this. Please, make the right decision and think about sustainability. Think about green. Osaka, she's growing lettuce in Manoa lettuce, you know. This is very good for us. This comes from China. You know, when I speak to my 102-year-old auntie who just passed away a few days ago, and my uncle who's 85 right now, I take him around the island every once in a while. I asked him what, he says, you know what? When you eat, make sure it comes from the Aina. Do not eat man-made things. Now please, here we have this. We need to stop these people and we need to stop them now. We can't allow these kind of things to happen on our land. We have to protect our land for ourselves, our keiki and our grandchildren. Don't ever forget that. Please, when you make a decision here in Hawaii. That's all I'm going to ask you. I respect every one of you and I respect your job and your decision making. But we have to respect one another and all ideas on the table. We put the ideas on the table and work together to solve a solution and come up with a fix. Please make things right, make things pono, so that we can all survive in our islands. Mahalo. Thank you. Your sense. Have a blessed day, all of you.
Morning. This is the new gang, huh? All new. How many? 4 or 5 guys, all new. I'm here this morning, flew in from Molokai, and I represent really myself and the public. That's my only interest here today. As far as beneficial and how that impacts, the social impacts of this issue that's before you guys, it's huge.
Even though you know, you
Oh, my
need to
name?
state your name for it, because it's not a family.
My name is Lee from Molokai. So, I guess the first thing I want to try and get across is how important this issue is, not only for water, but for the whole community. The impacts on our communities are huge. This company and the impacts are huge. Every little thing has an impact on all of us. So I felt like I needed to come and at least share some of the impacts that are happening on us. And listening to the reasons why all of this is happening, they're going into new areas far as the commission is concerned, we have to decide whether it's justified for them to break new ground. They call it backup, and it sounds good, backup. The staff is calling it double dipping, water banking, double counting, all those terms to try and explain what is going on. For us on the outside, it's getting very confusing about what's going on. But we all know that water is the issue, and everything is limited. I come from Molokai, and we know how limited water is. So we fight over water tooth and nail to make sure our future generations are protected. So I don't think this is any different. So whatever the name you call it, these guys want to bank surface water, and then they want to use potable water. So it will come from two different places, one from the ground, one from the top, one from the other side of the island, one from this side of the island. So in our eyes, somebody is stretching out their long tentacles to make sure that they're going to be proper. On Molokai, our tutu tell us that in order to be a farmer, you have to know how to pull it. The only way you know water is to pray for water. And that's how they have to farm. That's how the homesteaders start. So farming is nothing is guaranteed when you farm. So in this case, they want to guarantee. And in order to guarantee, they want to come to the public source that belongs to all of our future generations. So you got to make the decision whether or not you will guarantee these farmers. You know, farmers are actually gamblers. In this case, it's huge stakes going on. So they want to make sure that they get water. So you got to decide whether or not you're going to give them the water. And as far as the public is concerned, these guys are huge. What we see is the foot in the door to you guys' door. However they come in, and we call them back up, call them something nice, call them whatever, get the foot in the door, and then all hell can break loose. These guys got more money than we got. They got more lawyers than we got. They can talk nice in the 1980s, with all respect, and come in the door. So before you let them in the door, you better make sure that it's a good reason. Because once they get in the door, and having a backup is not a good reason to change our codes and to jeopardize the future of our codes. These codes were worked on years ago. I don't know how he can keep his cool over here. He's the guy that's working the hardest on these codes. If you're not going to believe him, who the hell are you going to believe? So I'm here to suggest that this large foot in the door is very, very dangerous as far as the community is concerned. We're taking jerks out there. The way these guys are farming, the community is taking jerks. We're breeding dust every day. We see Molokai turning into a dust bowl. We see the dust and everything going into our reefs. In the dust are all these chemicals. These are chemical companies. I don't know what kind of farmer these guys can be. I can only guess. So as far as the community is concerned, we do not support this kind of water use. And, you know, being fair and equitable, they have other alternatives. They have to exhaust those alternatives before they come and get a water use permit, which gives them the guarantee forever and ever. They can take you to court, even though a lady over here, a nice lady says, no, they're not going to take you to court. Yeah, I can tell you to move. Guarantee they're going to take you to court. So you cannot be gullible with this kind of marriage, and you have to be staunch and steadfast in protecting our public trust. And the public does not trust the situation one bit. We're suffering out there as communities, and we're worried about our health on this issue. So you need to take that into consideration in your decision making. Thank you.
Question for I have one comment. Don't worry, you're not the only one confused on the issue. It's confusing to us as well.
So don't take a chance. Thank you.
Mahalo for fun.
Miko po malele, miko po ina naman. Wao no ka uhana wi makmupuni Molokai hawa. Yes, I'm the son of Carol Farm from Halala Molokai, the same place where water really comes from. He Nui Kanina ya oko waka. I have lots of questions. So you give the permit to this powerful organization whose home is based not in Hawaii, and they take you to court, and they take you to court. We know how long it took Waihole to get 16 million gallons released back into the river. And during that time, the big, powerful organization fought and fought and fought. When the 16 million gallons was restored, for that period of time that they took water from the oil, they didn't have to pay for it. They just took it. Because the law allows for them to take and call it correct, because the law says it's correct. The law says it's correct. We can remember when women were not allowed to vote and the law said that was right. We can remember when blacks were being murdered and the law said it was right. The law is not always right. The law is not always right. I'm afraid that this organization is power-based. It's not in Hawaii. It's not in Hawaii. And I don't believe in giving that kind of right, innate cultural right, to someone else. I'd rather have the state manage the water, all the water system. At what point in time when water dries out and we need water from there, how much will that water cost you and I? Will they charge us for it? They sure they're going to charge us for it. Can Kawa'u go without water for 5 days? Possibly. Can Kawa'u go without gas for 1 month? Yes, I can go without gas, but I cannot go without gas. So the question about backup always comes as backup. Let me tell you a story about Halawa Molokai. My father's a farmer in Halawa, and the valley was owned by, at one point in time, it was owned by a number of people. But when Murphy came on, he wanted to take water from Mo'ula waterfall. He took the water from the area at Pu'ohoku and dried everything else below. There was not enough water. So they wanted to take water from Halawa. My father and all the farmers in Halawa Valley always wanted to grow more taro, but didn't have enough water. They didn't have enough water. So they adjusted to the situation. They adjusted. Because the adjustment was a moral right. It looked at the moral well-being of the people in the valley. So my father, at one point in time, harvested 400 bags of taro a month. Top in the entire state of Hawaii. King of taro, 400 bags. No one can ever tell that. Can you imagine the taro farmers on Kauai, if water began to go there, and they start asking for backup? They're not asking for backup for water. They're managing water as a farmer does, because the farmer's belief is that we all benefit when we take care of the land. Water is not the state's responsibility, it's all of our responsibility, everyone's responsibility. We cannot look at water for one person to benefit. It cannot happen, it cannot ever happen. How many of you gentlemen know what the word kanawai means and where it comes from? You know what kanawai is? I'm not picking on you. I'm just asking you to look at it. It's an intellectual question as well as a cultural question. It's a spiritual question as well. What does the word kanawai mean? Can I get an answer if you don't know it?
Yeah, division of water, that's our law.
Division of water. It's at this level. You're on the mark. But kanawai. Let me tell you the story. It was about a man who wanted control of water. Something like Monsanto. They're asking for control. But they have a nice word called backup. Everybody should be on backup. Everybody adjusts to backup. Everybody adjusts to backup. Farmers always think about backing up. But they don't ask for themselves. Because farmers believe that they make the adjustment. If there's less water, you plant. So the word kanawai, there was a gentleman who wanted water. He had control of the water. Control of the water. I, the other farmer below, saw that the man who had control of the head of the water was not allowing for life in the community, in the ahapua, in the moku, to survive at its highest level. He had control. Took him before gentlemen like you folks, the commission. But back in there it was called the Aimoku. And both sides presented their story. One said, no, it belongs to me and I want all of it. Kind of like where this is going, but the words are nice, called backup. It's really about control. Yeah? Relevant control. And so after hearing the story, the word comes, Maho'olelo Hawaii, Kanawai Kelawai. And the ali'i said, the water belongs to you. And all those back of you who want to farm. Not to you who's trying to control the water for yourself. Thus, the word Kanawai has nothing to do with water. It had to do with relationship. It had to do with life, the sustainability of life. So the one individual who wanted to control was not given that right to manage the water. It was given to the individual whose purview was greater than I. That's your task, to look after us all. That's your task. I vote no on allowing banking. I vote no. And I'm not alone. I'm not alone. In Makaha, we want to get water from the border water supply because they have wells. Not much. Enough for 4 taro farmers to begin. We have a hard time getting water from there. We have a hard time. We should be allowed to ask. We're not asking for a lot of water. We're not asking for all of the water. We're asking for 4 farmers to begin. If we allow 4 farmers to begin, why is it that we should not be looking at taro as baby food for the world? Why shouldn't we produce that? But we should not produce taro, GMO taro. Absolutely not. It's culturally insult to us. But we can grow enough with our own technology, with our own ike from a cultural perspective. And we all have cultural perspective. That's where we need to go to when we make our decisions. We need to really reach back. What would your great-grandfather say about water? What would your great-grandfather? What would your great-grandmother say about water? There's a conference in California about the struggle for water. All the governors of the states went there. They all went their list of what they wanted. And when they left, they left with what they needed, not with what they wanted. Mahalo.
Anyone else wishing to testify on this issue? My name's James Macy, just a concerned citizen, not representing anybody. Now Monsanto sprays a lot of pesticides and herbicides up there in Kuhia. They run, 4 crops a year, 3, 4 crops a year. And I'm concerned as a citizen that you're putting a well in the midst of all that poison. It's like putting an IV of poison into our water table. All right? I've asked the water supply, Board of Water Supply, do they check for pesticides and herbicides? And they said, yeah, they do check for some pesticides, but I get crickets when I ask them about herbicides. And I'm just as concerned about herbicides as I am about pesticides. My question to you guys, or to you, Mr. Chairman, I guess, has Monsanto provided you a list of poisons that they spray out there in the community? And do you guys check for those in our water supply, our potable water supply that we drink, and also our water table? I personally would like that test done before you guys approve this. For actually, the Water Commission doesn't test the water supply. They're responsible for testing those kinds of things. That's the answer.
I'd like to test it before we approve this.
I had actually made a similar comment and request at the first meeting where this issue was brought up, that the original wells that were serving this property under Dole Company are polluted with chemicals that were added at the time of Dole planting and cannot be used. In fact, there's an EPA consent decree to clean up that plume, and that there's likelihood of chemical additions to the soil. I had put in a request that we condition any action on this in a way that the applicant would have to provide us a list of all chemicals all pesticides, herbicides, fungicides, anything else that was added in the wellhead protection area or on the lands. I still feel that there's merit to that, but I've been told that that's not really our issue as a commission, that's wellhead protection areas, and that is under Department of Health. We do have a director of Department of Health on this board. She's not here right now, but I have asked staff to report back to us on what mechanisms we can utilize to ensure that our valuable precious aquifers, which are our life, do not become polluted, and that we know what's going into the ground in the future. We don't need to make the same mistakes that we made in the past.
Yeah, it seriously concerns me that we're gonna put a well out there and this oil is poison. I want my water tested before this goes in.
Thank you.
Thank you.
One more time for Mr. Wright, anyone wish to testify?
Aloha, my name is Oponaki Aloha. Again, I don't like being here because you guys actually don't belong in control of our sovereign nation. There's no treaty, there's no annexation, but to have a global corporation come in here and basically suck us dry for everything they can get and then dump us, toss us like some piece of Opala. They don't care about our island, about my new land. This is my place. My children and their children's children will be looking at me when they can no longer eat or no longer drink what's from our island. We have to think about that. You have children, you have family here. There's a lot of information of the HEVA about Monsanto and what they've done to other nations and countries. India, you gotta go online, you gotta Google it. Roundup is like a form of Agent Orange. Look at what it's done to Vietnam. This is what they're putting into our island, into our water, into us, into our soil. The FDA is a revolving door of Monsanto. They have CEOs that go in there, turn their heads, and get out, back into Monsanto. You guys have to do your research, okay? But you have family here. You drink the water here. You gotta care about that. Care about yourself, your families, but especially appreciate the people that were here, that we're standing on Iwi Kupuna, the day approve of this. Mahalo.
Good morning. My name is David Martin. I'm a long-time taro farmer and have followed the Water Commission for many years, since its inception. My concerns have always been in the area of the processes that have accompanied the water code and the whole subject of planning. To me, this matter really should not be treated as a permitting matter. It should be treated as a planning matter. This is totally dealing with subjects that are already set up to be managed under the water code, water shortages. And there are many questions. I would very much like to applaud the staff for the work that they've done on this so far. The observation, recommendation, and the efforts that they're trying to walk a very fine line here. Denying a water use permit, but going forward with a well. I have some concerns about that, mostly related to the issues of the use of the land. It's, toxicity. It's pretty well recognized globally that we're having major problems, and on this same piece of land, we've dealt with the issue of, toxicity in the water. I don't really believe, although the staff says that they have enough information to move forward on this at this time, I disagree. I don't see why there should be no consideration of the reasonable and beneficial use of the water coming out of Waihole. You have a new user, you have new crops. I think that should be on the table at this time. They've opened the door. And it should be addressed. We have studies that are showing major declines in stream flow that are still being studied. What water is actually available coming out of Waihole right now? Do you know? What have the flows been? What have the flows been since the award? Have there been reductions? There's a study that says that there's probably a 20% reduction. Whether that shows up in the ditch flow, I don't know. But I don't think you folks know. We have the whole issue of recharge, the availability of water in this aquifer right now. It's under study. We're looking 2 years out before we have an answer. We have the whole subject of reused water, a study going on about that. Is it available or isn't it? These folks have been asked to provide information about that, but they haven't done their work on that, according to the submittal. They haven't provided you information. At this point, on page 5, it's indicated that Waihole ditch water is the Commission's preferred source for water in this area. I disagree at this point. I don't think that you have enough information to continue on that assumption, especially considering the effects that have been occurring to stream flows that have been already identified and presented to you. Your public trust obligations have been very well covered by the preceding speakers immediately before me. From the heart. I cannot add to that. I believe all of these applications should be deferred. I believe there should be the completion of the water plan that was supposed to have been done 25 years ago, that has not yet been completed. And again, this is a planning matter. This is a long time, drag-the-tail issue that has never been addressed. Complete the regional water use and development plan. I started at the very beginning of this code addressing the subjects of Hawaiian interests in water rights and stream flows. And that's been the primary concern. How, in the planning process, is this ever going to be addressed? It's obvious that it's been kicked down the road. It can have gone and gone and gone. It's been kicked down the road. And now you have some people, corporations, not people. This is a corporation coming before you. We had people testifying before you. I would certainly hope that you would regard the testimony of real people above the testimony of the corporate interests. These people are not going to provide food for us. They may provide some jobs and a lot of workers' compensation claims. But it's in your lap. I don't envy you the position. But I highly, highly hope that you will honor the requests of the local folks here and understand their interest in protecting the water into perpetuity. I cannot accept any decision that would allow this corporation to get their foot in the door first, before anybody else. This is the privatization of water interests. You must understand that, and you must respond to it accordingly. Mahalo.
Anyone else wish to testify? Okay, so
Yes, I'm going to go to executive session. Talk to AG's office. Get some clarification on some more.
second one, executive session. Okay, there's a second, all those in favor say aye. Aye. Any opposed? No. Hallelujah.
I hope to go into executive session, but I would like staff to be able to join us.
I don't believe that concept. In executive session.
I will not.
Okay, so one vote, no, there's 1, 2, 3, 4, 5, so go into executive session, we will be back. We will be back too, be back. Good to see you, Rob. Good to see you, Bill. Go ahead and meet in my office.
They're breaking for an executive session to call the Attorney General's office to ask for an opinion on some of the legal matters that were brought up. I don't know how long it'll take, but it seems that people are going to stick around. There's some great testimony. I might break away shortly, but we'll come back. I hope to get around to editing some of this video because there was some really good testimony here.
Man, you're all over the place with that little machine, huh?
Well, it helps get the word out, let people know what's going on.
Guy in the cap and blue shirt flew in from Molokai. He's a farmer. He gave some eloquent testimony. I think I'm gonna break away, take a little break myself. Stay tuned to @HDoug on Twitter and my Facebook page, and we'll broadcast a notice when the executive session is over and people come back. Cutting away. I'll be back shortly.